Ready? 1, 2, 3, start. The purpose of the suit for partition is to carve out the respective shares of parties and to deliver their separate possession of plain schedule property. Partition is a redistribution or readjustment of pre existing rights among co owners, co parceners, resulting in a division of lands of other properties jointly held by them into different lots or portions and delivery thereof to the respective allottees. The effect of such division is that the joint ownership is terminated and the respective shares vest in them. A partition of a property can be only among those having a share or interest in it. A person who does not have a share in such property cannot obviously be a party to a partition. Separation of share is a species of partition. When all co-owners get separated, it is a partition. Separation of shares refers to a division where only one or only a few among several co-owners bar co-parceners get separated and others continue to be joint or continue to hold the remaining property jointly without division by metes and bounds. With these conceptual aspects in the backdrop, let me dwell upon the factual matrix in the light of oral and documentary proof. It is the specific case of the plaintiffs that suit schedule property is the ancestral and joint family properties of plaintiffs and defendants. It is contended that plaintiff number 1 is the second wife of Bhimappa and plaintiff number 2, 3 and defendant number 8 are the children of plaintiff number 1 born through Bhimappa. It is specifically urged that there was no partition by metes and bounds between the parties. It is the grievance of the plaintiffs that defendants in collusion with each other are trying to alienate the suit schedule properties so as to snatch away the rights of the plaintiffs over the schedule properties. Though the plaintiffs have requested the defendants to partition the suit schedule property, but they have turned their deaf ears to the request made by the plaintiff. Hence, without having any effectuous remedy, the plaintiffs have filed this suit for partition and separate possession. In support of the case of the plaintiffs, plaintiff number 2 stepped into the witness box and filed affidavit in lieu of oral examination in chief as PW1 and got marked Exhibit P1 to 12 documents. The plaintiffs, in order to strengthen their case, have also got examined one Bhupal Maruti Uppar as PW2 in order to falsify the contention of the plaintiffs and to substantiate the defense of the defendant number 1 to 6, their counsel has cross-examined PW1 and PW2 at length. It is the defendant number 1 to 6 who have resisted the case of the plaintiffs. The whole fulcrum of the defense of these defendants is the plaintiff number 1, 2, 3 and defendant number 8 are no way connected to the deceased Bhimappa. The defendant number 1 to 6 being the wife and children of Bhimappa have succeeded to the property of Bhimappa. The defendant number 7 was gone adoption. As such, his ties with genitive family was served. It is also urged the plaintiff number 1 was given marriage with one Parasappa Adinavar of Melavanaki in Gokak Taluk. It is also urged that plaintiffs have no nexus whatsoever with deceased Bhimappa. As such, there is no question of partition of the suit schedule property. Hence, pray to dismiss the suit. In support of these contentions, defendant number 3 stepped into the witness box and filed affidavit in lieu of oral examination in chief as DW3 and got marked Exhibit D7 to 36 documents. Further, the defendant number 7 filed consent written statement and defendant number 7 himself stepped into the witness box and filed affidavit in lieu of oral examination in chief as DW1 and got marked Exhibit D1 to 6 documents. Defendant number 7 also got examined one Kallappa Jyoti Nayak as DW2. He, during his chief examination, has completely supported the case of the plaintiffs herein. The whole dispute in controversy in this suit is with regard to the relationship between the parties. It is the specific case of the plaintiffs that plaintiff number 1 is the second wife and plaintiff number 2, 3 and 8 are the children of Bhimappa born through plaintiff number 1. But on the other hand, it is stoutly urged by the defendant number 1 to 6 that there is absolutely no nexus with plaintiff's defendant number 8 with that of Bhimappa. At the same breath, it is also specifically urged that plaintiff number 1 was married with one Parasappa Adinavar of Melavanki village in Gokak Taluk. As such, she is totally stranger to the family of the Bhimappa. In order to substantiate the factum of relationship with that of the Bhimappa, the plaintiffs have not at all produced any string of evidence. The plaintiffs have just produced the RTC, which is standing in the name of one Mayappa, who is none other than the son of Bhimappa. The plaintiffs also produced the entries and such other revenue documents which does not sheds any light with regard to the relationship between the parties. The plaintiffs, in order to prove the relationship, have just produced Exhibit P12 photograph. It is relevant to note that the said photograph was also not snapped at the time of marriage. When such being the case, mere production of some photograph does not establishes the relationship of plaintiffs with that of deceased Bhimappa. It is pertinent to note that Exhibit P12 photograph is not accompanied with any negatives or CD. As such, this document also suffers mandatory requirement as contemplated under section 65 clause B of Indian Evidence Act.